Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss about the term legal heirs and how to get the legal heir certificate. The term legal heirs denotes the close relatives who are entitled to inherit the properties of the deceased. Deceased means died person. Supposing a man or a woman dies, he or she will leave so many blood relatives. If he is a man, he may leave his wife, father, mother, son, daughter, grandchildren, brothers, sisters, and other blood relatives. Similarly, if a woman dies, she may also leave various relatives. So, the term legal heirs denotes those persons who are entitled to receive the properties of the died person, deceased, the properties of the deceased. So, those persons who inherits or who get a share in the properties of the deceased are called legal heirs. Normally, father, mother, or son, daughters, grandchildren, husband and wife will all come as a legal heirs depending upon the religion. If he is a Hindu, the Hindu Succession Act will apply. If you see the Hindu Succession Act, the act stipulates various types of legal heirs. First class legal heir, second class legal heir. So father, mother, husband, wife, children, grandchildren are declared as the first class legal heirs. Similarly, if a person dies, is a Muslim or a Christian, the respective personal law will apply. For the rest of the persons, Indian Succession Act will apply. So, to decide whether a particular person is a legal heir or not, we will have to look into the respective personal law, like Hindu Succession Act, or Muslim law of inheritance, or Christian law of inheritance, or an Indian Succession Act. So, legal heirship will depend upon the personal law. Now, who are all come under legal heirs with respect to Muslims or Hindu or Christian? That aspect we will discuss in another video because it will be a lengthy one. Now, let us see how to get this legal heir certificate. So, in order to get the legal heir certificate, we will have to approach Tahsildar in Tamil Nadu. Tahsildar is the proper authority issuing legal heir certificate, and he alone can issue the legal heir certificate. So, in order to apply legal heir certificate, there are two types of procedure: online procedure and personal procedure. Initially, every application to the Tahsildar office has to be submitted in person along with record papers. Nowadays, some of the Tahsildar offices are adopting online submission procedure. In some of the Tahsildar office, they are insisting to submit the papers, documents in person. So, depending upon the Tahsildar office, you will have to follow the respective procedure. So, where can you apply this legal heir certificate? You can apply the legal heir certificate where the person deceased resided or where the person dies. So, these two places will be the proper place. Suppose a person dies in Chennai and he resided in Chennai, then in the respective Tahsildar office where he resided will be the competent authority to issue the legal heir certificate. So the residence and the place of death will be the important factor. It will decide the correct authority who is capable to issue this legal heir certificate. So once you approach the Tahsildar office, you will have to submit the necessary documents along with your application. So first of all, you have to file an application. The application can be filed by any one of the legal heirs. They have to produce the documents called death certificate of the person, voter's ID, Aadhaar ID, ration card. This document, the ration card, voter's ID, Aadhaar card will be taken as a proof of residence, and death certificate is also required. So in order to get the death certificate, we have to register the death with the concerned birth and registration authority. So once a person dies, immediately within 48 hours, you will have to go and register the death of the person. Sometimes for the death of to register the death, they may also, the concerned birth and death registration authorities may ask you the doctor's certificate. So now in Chennai, for registration of the death, they are insisting to produce the doctor's certificate. So once a person dies, immediately you will have to approach a particular doctor and get a death certificate saying that he has died not naturally for any reasons. Suppose he dies for a heart attack or for any other ailment, he may specify the reason. So the doctor certificate, the doctor has to state that the person has died, and if he is able to find out the reason for death, then that is also to be noted in the doctor's certificate. So once you complete the necessary formalities, say after the burial or after the necessary religious formalities, you can go and register the death of the person along with the doctor's certificate. Once you register the death within a week or within 15 days, you can get the death certificate from the corporation authority in Chennai, in municipal authority from other towns, or some places you can get the certificate from the local panchayat people. Once you receive this death certificate, then you will have to apply this legal heir certificate with the Tahsildar office along with death certificate and all the other documents, including the voter's ID, Aadhaar card or ration card of the legal heirs. Suppose a person dies, not the death certificate and the Aadhaar ID, ration card of the deceased. In addition to those documents, you should also produce the Aadhaar, voter's ID, ration card of the legal heirs. So these are all the vital documents required to submit the application for legal heir certificate. Then in some Tahsildar office, they will all insist you to get some statement from the neighbors. You may have to submit the statement from the two neighbors, or some office they will insist for 5 statements from 5 persons. Some office they will insist to produce a statement from 10 persons. So depending upon the requirement, depending upon the instructions given by the concerned Tahsildar office, you will have to get a statement from the neighbors. The neighbor will have to state that I know personally the so-and-so person dies in the so-and-so locality and so-and-so date. I know that he left the following person as legal heirs. I personally knows all these family members. Like that, they have to give a statement. So if the statement is produced before the Tahsildar office, it is easy for them to verify the facts and give and issue you the legal heir certificate. So the statement of the neighbors is not a compulsory requirement stipulated under the law act, but it is a procedure. It is being followed in various Tahsildar office. So you will have to get a statement and submit those things along with your application. Once your application is filed, whether in person or through online, then it will be directed. The application will be forwarded to concerned verifying authority, maybe RI or any other surveyor. That person will come to your place and he will personally inquire with the nearby relatives, and they will, after verification, personal verification, give a report to the Tahsildar stating that so and so person is died on so and so date and so and so place, and he has left the following person as legal heirs. So on the basis of this legal report given by the verifying authority, the Tahsildar will issue the legal heir certificate. In most of the offices, they also insist to produce an affidavit from the notary public like me, stating that so and so person dies at so and so place and so and so person left the following person as legal heirs. So that will be an official additional proof or confirmation or statement issued by a notary to the fact that the so and so person has left the following so and so legal heirs. So in addition, along with the application, it is also better to submit a notary affidavit stating the legal heirs' names and details and relationship with the deceased. That will also help you to get the legal heir certificate immediately. Now you may ask, why should we get a legal heir certificate? So supposing a person dies and he has put some amount in the bank account, savings account or fixed deposit, or supposing the person has some share certificate, or supposing the person is an employed person, he got pension or any other benefit from the company. If you want to get those things, immediately the bank or the authorities will insist you to produce the legal heir certificate. So without legal heir certificate, you cannot get back the money which is deposited in the deceased name. So whether it is a bank account, a bank deposit, fixed deposit or share certificate, the legal heir certificate is a must, and it is without which it is not possible to transfer the fund to your name, or it is not possible to get those amount from the bank or from any other authorities. Similarly, if a person left any immobile property like land, building or any other assets, in that case also, supposing you wanted to transfer it to any other person, suppose you wanted to sell the property, or if you wanted to partition the property, or if you wanted to get a loan from the bank on the basis of the property which is you inherited from your relatives, in that case also the concerned authorities will insist you to produce the legal heir certificate, because that person, supposing the property stands in the name of A, and the document will only show that the A is the owner of the property. So suppose you want to say that I am the legal heir, once a person dies, then the concerned authority will definitely insist you to produce the death certificate and the legal heir certificates of the parties. So without which it is not possible to you to transfer those properties or to get the money back from the bank or from any other person. So the legal heir certificate is a mandatory one. It is a must thing. We have to get it from the Tahsildar in time. One of the important factor is that you have to apply this legal certificate in time. Suppose you commit a delay for 5 years or 10 years, then it will be difficult to you to get the legal certificate, and the authorities may also may not come forward to issue the legal certificate. They may direct you to go to the court, and they may direct you to get the same from the court. It will be a problematic one. So as far as the Tahsildar is concerned, he will simply follow the Revenue Recovery Act. So the Revenue Recovery Act stipulates some of the legal heirs some of the person as the legal heirs: father, mother, sons, daughters, grandchildren, or these are the common legal heirs to all persons irrespective of the religion. So the Tahsildar will issue a legal heir certificate only if the relatives, the legal heirs, comes under the category enumerated under the Revenue Recovery Act. Suppose there is a complex of question, suppose it is a difficult job, then the Tahsildar will not come forward to issue you the legal certificate, and he will direct you to go to the court to get the legal certificate. Suppose a person dies, sons, daughters, father, mother or grandchildren, then it will not be difficult to you to get the legal certificate. Suppose a person did not left any sons, daughters, husband or wife or father or mother, and he left only the distant relatives. In that case, the Tahsildar will not issue you the legal certificate. They will direct you to go to the court and get this legal certificate. Similarly, when there is a complex question of law or when there is a rival claim, complex issues are there, then in that case also the Tahsildar will not issue you the legal certificate, and they will direct you to go and approach it from the approach to the court to get the same from the court. So supposing the court Tahsildar refuses, then the option available to you is you have to file a suit for declaration from the concerned city civil court or municipal court or high court, and then you will have to get the legal certificate from the court. So by filing a suit, you can get legal certificate from the court. Sometimes you can file application for letters of administration. Suppose a person dies and execute a will, then in that case you can file an application before the High Court and get a probate if the person dies within Chennai. In other areas, then you will have to apply the legal probate from the concerned district court. If the person did not left any will, then in that case the legal heirs are entitled to get legal heirs, that is called letters of administration. The letters of administration is nothing but a type of legal heir certificate issued by the competent court. So legal heir certificate is a document issued by Tahsildar, and letters of administration is the document issued by the High Court or District Court. Suppose the value of the property is so high, or suppose a person deposited huge amount in the bank as FDs or savings account, or suppose a person has deposited huge jewels in the bank account, then the bank authorities may insist to get a letters of administration from the competent court. So letters of administration is the powerful document which will be more valid, more powerful than that of the legal heir certificate, since it is being issued by High Court or principal district court. So this is the things which I want to convey through this video. So legal heir certificate is legal heirs are those persons who are entitled to receive the property or share in the properties of the deceased. And for the legal heir certificate, you will have to approach Tahsildar. If Tahsildar refuses to issue any legal certificate, you can approach the court and get the legal heir certificate. I hope this video will be useful to you. I request you to give your comments, and I also request you to watch my videos and give your support. Knowledge is power. Legal knowledge will not only give you the strength and power, but it will also give you the boldness. Knowing the law is not only a strength to the people, but it will also give you a powerful, bold life to face all the difficulties. So through my channel, I am publishing various videos under various topics. I hope those videos, you can watch all the videos under various topics, under various playlists, and you can clear your doubts. In addition to that, if you have any specific doubts or clarification or legal opinion, you may also contact me to the cell number given in this video. And if it is possible to us, we may also give you the lesser required legal assistance or legal consultation. depending upon the availability of my time. I hope this video will be useful to you. I will come again with another video with another topic. Until then, goodbye.